Hello, I am Renee Matthews Jackson. The First Amendment: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press or the right of the people peaceably to assemble and to petition the government for redress. The New York Times ran a full-page ad purchased by civil rights leaders to help Dr. King with legal fees. The ad highlighted police brutality and had errors regarding some facts. This led Commissioner Lester B. Sullivan to file a lawsuit in Alabama courts because he felt the ad tarnished his reputation as commissioner. According to their state laws on defamation, he was shown favor by the court. The New York Times appealed to the Supreme Court. The Supreme Court ruled in favor of the New York Times, setting a precedent protecting freedom of speech and freedom of the press. Public figures had to prove malice with knowledge of the truth. In the past, someone could sue because they felt they were harmed by the press or new media without having to prove malice. The Times did not knowingly print the ad to do harm to Commissioner Sullivan, but to fundraise and support the civil rights movement. Sullivan was unable to prove otherwise. In conclusion, it is easy to understand that Mr. Sullivan felt his reputation was harmed. But the evidence of brutality was being displayed on television and radio as it happened. The error regarding the times that Dr. King was arrested was a common mistake, being that he was arrested about 30 times in 1964 alone. The win was for free speech, freedom of the press, and the protection of good journalism. Much like the Sullivan versus the New York Times decision, this too is a landmark case between Gertz versus Welch. This case distinguishes the difference between a public citizen from a private citizen and how defamation lawsuits work. I invite you to watch the video. Just click on the symbol that says watch the video.